Which should I apply for? Asylum, withholding of removal, or protection under Convention Against Torture, CAT, protection under Convention Against Torture. In this video, I'll talk about the aftermath. Once the immigration judge denies the application of asylum in removal proceedings, what can you possibly do? Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, come on, you know what to do. Please go ahead and share, like, and don't forget to comment below. Let's get right into it. What should I possibly do? Well, once you apply for asylum, when the applicant is applying for asylum, it is important that the applicant check all options. Basically, there is a checkbox on the right, really at the front, basically the first page of the I-589 application for asylum and withholding of removal. You can check that box that says protection under Convention Against Torture as well. So basically, you're claiming everything that can be available to you. So, but what are the qualifications? That's what we'll be talking about it. But the reason that you want to check all boxes because you don't really know how this entire asylum application will turn out. And when it comes to asylum, my friend, you have to remember that asylum is discretionary, subjective, basically, and really they look at credibility of the evidence and whether there is a reasonable fear of persecution, well-founded fear of persecution. So as to speak, the standard is very low, so they can deny the application basically just for a simple reason as well. The evidence is not verifiable, or maybe the document is not authenticated, something as simple as that. Instead of just telling you, well, provide another document, you can find yourself being denied the asylum benefit because it is discretionary. That's why a lot of people find themselves in removal proceedings. But when you are there and you do not have any other options available as far as adjustment of status is concerned, some people, of course, have some options and they can adjust status in removal proceedings. For example, they can adjust status based on marriage. They can adjust status based on a child petitioning for a parent. Of course, we're talking about a child over the age of 21. But some people do not have those options at all. Whether an employer can petition for them, they do not have those options at all. What can you possibly do? That's when you move for withholding of removal. So I know it's a form of limitation when it comes to benefit, but it is an option if the person does not really want to return home. So, and they fear persecution, right? So withholding of removal, what can you possibly prove? Well, before we get there, we have to we have to really tell you that withholding of removal, it's a mandatory form of relief. Meaning what? Meaning that if you meet the requirement, the judge has no option but to grant you withholding of removal. Pretty much so. The law is very clear. It is mandatory. So basically, if you meet the requirement, the judge has no option but to grant you withholding of removal. It comes with its own limitations. We're going to talk about those. But anyway, what can you possibly prove when it comes to withholding of removal? You have to be able to prove you have to, first of all, prove that you are a refugee and that there is a clear probability of your persecution by a government if you were returned to your country of origin. Clear probability of your persecution. And how do you prove it? Some people bring evidence of country reports. For example, if there is a lot of human rights violation in that country, you can show those reports, pretty much showing people being persecuted and currently still being persecuted based on the thing that you were claiming in your asylum application. And once they verify the credibility of the evidence, really the judge has no option but to grant you withholding of removal. Say that the judge has granted you a withholding of removal. What are the limitations associated with it? Basically, you cannot travel outside of the US. It means that you cannot apply for a travel document because you cannot travel outside of the US. And second of all, it is specific to you, to the person. No family member will benefit from it. That's a second type of limitation. Third type of limitation is that you pretty much cannot adjust status on your own, unlike asylum. Asylum, once granted, the person can adjust status after 1 year of the granting of asylum. But withholding of removal, the person cannot adjust status on their own once it's granted. The fourth limitation is that you have a work permit, but has to be renewed every time. And you know, sometimes some people find themselves, unfortunately, cannot renew those work permits for one reason or another. So those are the form of limitations that comes with withholding of removal. And the last one, really, I was almost trying to forget it, is that the person, some people will find themselves under a supervision order, so meaning that they have to check in with ICE every year, once a year or twice a year. Some people pretty much based, maybe they had some type of criminal background or so forth. Those are the reasons that will lead order of supervision, and some people will see the passport being confiscated, so being withheld by ICE. Those are again type of limitations that comes with withholding of removal. But is there hope? There is hope if later on in the process, right, you have a withholding of removal, and later on, let's say the person has a child, had a child that was under the age of 21, and later on the person has a child who's 21 working. The child can in fact sponsor for the person, and later on in the process, the person can in fact get a green card. It's a long road, not a clear path to a green card, but it is doable. People have done it before, after the fact, right? So when it comes to protection under Convention Against Torture, what are the requirements? Really, when it comes to that, CAT, you have to really prove that it is more likely than not that you will be tortured, okay, if removed to the country from which you are claiming protection. And you have to be able to define torture the way it is defined under CAT, Convention Against Torture. So, which is any intentional unlawful infliction of severe physical or mental suffering or pain with consent of public official for purposes such as punishment, obtaining a confession, intimidation, or discrimination. If you prove that, that's it. The judge has no option but to grant you the protection under Convention Against Torture, CAT. Once you've been granted that, again, it has its own limitation, which means that basically at some point, if they want, they can remove you to another country that they consider safe, if that country accept to take you in. So that's one of the major limitations that comes with it. You cannot adjust status on your own. Work permit, again, is limited, renewable. pretty much the only thing as guaranteed that it is that you can stay here for a limited period of time, or longer, depending on if they don't find another country to remove you to. So that's it for today. Basically, what I wanted to say to recap is that there's hope once an asylum application gets denied in immigration courts. Some people pursue appeal. Some people get, satisfaction basically on appeal. Some cases have been remanded back really to immigration court so that the judge can grant asylum. But in most cases, really, it's difficult because of the nature of the asylum itself. It's discretionary. Really, the standard is lower, and it is really subjective, and that's why it gets really difficult. So, but anyway, that was it for today. If you need a consultation with me, please call 22751-2180. Email on display. Consultation fees apply. Until next time, bye-bye.